And by the way, this odor of mendacity remains hanging over the case. There's an appearance of impropriety, they say, and there's an odor of mendacity that lingers in the case. And so they want the Court of Appeals to go in and clear up that odor and see if they can make it go away as you were. All right. So they point out to the judge that an outsider, that's us, looking in on this, could reasonably think the DA is not exercising her independent professional judgment, totally free of compromising influences. They go on to point to the judge that, look, judge, if you don't allow us to go ahead and correct this issue now, then it could come back to haunt you.
There's nothing more powerful than the odor of mendacity.
All right. Welcome back Inside the Law. I'm your host, Philip Holloway. In case you can't tell, the theme for tonight is the odor of mendacity, because we have all been waiting for the Georgia Court of Appeals to decide if they're going to step in and do something about the odor of mendacity. Well, we came a little closer today because the Court of Appeals here in the state of Georgia has ruled that they will accept the discretionary interlocutory, which means pretrial appeal brought by former President Trump, Michael Roman, and several of the other defendants in the Fani Willis RICO case. Now, let me back up for anybody who's new to the channel. And by the way, there's already 500 people in here. Thank you all. Welcome everybody, new people to Inside the Law, and those who have returned. I'm glad everyone's here. In case you haven't been following this case, just to sort of set it up, we have this Trump and multi-defendant racketeering case here in Fulton County, Georgia, and the district attorney, Fani Willis, was found to have been not only involved in a romantic affair with a private lawyer who she used a no-bid contract to bring onto the case, paid him lots more money than she would be paying a regular prosecutor who was a full-time assistant DA, by virtue of the fact that they were a romantic item, if you will. She received essentially kickbacks from the money that she paid the man, because he would basically spend it on her in the form of romantic getaways and trips and all sorts of things. And then, of course, she says, well, but, I kind of paid him back more or less kind of in cash, and there's no record of it. And there was this big hearing, there was testimony, and a lot of people didn't believe it, including the judge. Fast forward, now we have the trial judge entered an order that says, yes, there is either an appearance or maybe even an actual conflict of interest. Oh, and by the way, she's also engaged in something called forensic misconduct by talking publicly about the case that she's actively prosecuting, and in so doing, purposely sliming the defendants by name, calling them racist and everything else. That's just something you can't do. So for all of these reasons, these defendants asked the judge to kick her off the case because she's unqualified. The judge gave them 90% of what they needed, because he made factual determinations, guys, that these folks had done all those things, but he did not remove her from the case. He said, look, either you're going to have to go, or at least, you're going to have to remove Nathan Wade, your boyfriend, from the case. And of course, that's what she did. The normal process in criminal cases is that you got to wait until after there's a conviction, if there's going to be a conviction, and then you bring every error that you have in the case, you bring that to the Court of Appeals, and you say, this is how the judge screwed up in all these ways. Sometimes when things are really, really important, they can be done pre-trial, but you got to get permission from the judge. It's called a certificate of immediate review, but it's got two parts. The judge has to agree to it, and the Court of Appeals has to agree to it. Well, today, the Court of Appeals said, yes, we will agree to hear the case. And next, here's their order. I showed it at the very beginning. This is the order saying that they have 10 days to essentially file what's called a notice of appeal, and then the briefing schedule starts. So what happens next? Well, what happens next is the parties will file their briefs. These are all written documents that are going to be public record. I'm sure we're going to be right here inside the law talking about them because that's kind of what we do. We use real court cases to show you how the justice system really works. And we're going to do that here in a minute with something else that's been filed in the case. But we'll be able to review not only the briefs by the appellates, that's the defendants in the case, but we'll also be able to read the responsive brief by the appellee, which is the prosecutor's office at Fani Willis's office. They will, of course, be arguing that, there should not be any kind of disqualification. And then we're going to have oral arguments, and this is going to be televised, well, live streamed, I should say. The Georgia Court of Appeals will have oral arguments on this, and we'll all be able to watch. And I plan to be right there with you every step of the way. We're going to see what the lawyers representing the various parties have to say about the case when they argue. And we'll be able to get a sense of what the justices on the Court of Appeals might be thinking. We can kind of read the tea leaves by the questions that they ask. But that's sort of in a nutshell what has happened and what will happen next. I want to take just a minute before we get into I want to recognize our chat boss, Megan. Thank you so much for organizing and policing and keeping law and order in our chat room, Megan, but also thank you for gifting 20 memberships. That's very generous. Thank you so much. That's the kind of support that allows me to continue to bring you this content. And if you like it, make sure you subscribe, hit that like button. Feel free to support the channel. The links are provided for you in the description to the video. I wanted to, I guess, next move into this is something that I've done a video on before, but I want to sort of use this document to explain to you how we got here. Okay. And we might have a special guest joining us in a few minutes. So I'm going to be kind of on the lookout for that. By the way, if I sound hoarse, I'm a little bit, I've been here at this desk for several hours now. I just recorded an interview with Megyn Kelly on her show. I want you guys to check that out. It's going to drop, I think, on Megyn Kelly's show later, maybe later tonight or perhaps tomorrow, depending on the turnaround time. But we did an hour-long conversation. Basically, it's all about more than an hour, but it's all about the lawfare. We talked some about this case and what we're going to be going through with you right now. So check that out. All right. This is what we call an amicus brief. And this is what was filed by Jordan Sekulow and the American Center for Law and Justice. Now, what an amicus brief is, it literally means friend of the court. And this is when a third party, someone who's not a defendant in the case, and of course not the prosecutor, they weigh in, they file these briefs. They're called friend of the court briefs. That's what amicus curiae means in Latin. And they are urging the court to take a certain position. It's worth noting that there was an amicus brief filed, I think also by a third party, asking the Court of Appeals not to get involved in it. But this is the one that I like, so I'm going to talk about this one. I won't read it to you, but this is, I think, why the Court of Appeals has agreed to hear this case. Because for the reasons pointed out in this amicus brief, even an appearance of impropriety is just not acceptable in criminal cases, and it does, for reasons that we're going to talk about, erode confidence in the judicial process. And the odor of mendacity, where that comes from, for those of you who may not be familiar, that's the trial judge used that very language in describing essentially, the behavior and in particular the testimony of the district attorney when she testified. Odor of mendacity means that it's just not believable. All right. And so they're saying this court should weigh in here to ensure that the odor of mendacity that pervades this case is removed before it's too late. And by that, they mean before somebody gets convicted after an unfair trial. All right. So interesting here, they cite to a bunch of cases, and it's an interesting variety. Berger versus United States, that's a Supreme Court case from the 30s. They go back to a Georgia Supreme Court case from 1852. They've got a 1916 case from the Georgia Court of Appeals. They look to New Jersey. When lawyers cite cases from other jurisdictions, that is what we would refer to as persuasive authority. You're not offering that case as some sort of direct, case law from this court system that's like prior precedent from Georgia. You're just saying, look, this is how other states have done it. We think that's a good idea. You should kind of do it the way they did it. They cite a 1988 case from the U.S. Supreme Court, some Georgia statutes, and under where it says other authorities. I haven't done this yet, and maybe some of you guys want to. I'm actually gonna try to track this down. This is what's called a law review article. It's published by the law review articles are published by law schools, and sometimes the articles are written by students, but oftentimes by professors or other people who are experts in certain fields. And this is one. It's called Rethinking Prosecutors' Conflicts of Interest. I guess that's British Columbia Law Review from 2017. All right, so I'm gonna make it a point to go back and find that. I'm gonna look it up, and maybe we'll talk about it here, but I would encourage you to kind of look at it as well. Here they say the ACLJ's specific concern is the integrity and preservation of the judicial system in a case with national implications. The ACLJ files this brief on behalf of its members who reside in Georgia, as the district attorney at issue in this case represents quite literally the entirety of the people of the state of Georgia. The ACLJ also files this brief on behalf of members who do not reside in Georgia, but who are concerned that their ability to meaningfully vote for president may be hampered by a politically motivated and infected prosecution still very much bearing an odor of mendacity. I just love the odor of mendacity.
There's nothing more powerful than the odor of mendacity.
And I think that's very true. It's very, very powerful stuff. And the judge used some very colorful language, but if we get nothing else out of this case, I hope that we will continue to use that phrase to describe what's going on in this case. All right. So the idea here is that the Court of Appeals should go ahead and get involved in this case in order to preserve the proper administration of justice and to prevent what they say is the maladministration of justice by granting review to correct the trial court's failure to disqualify a DA based on the glaring conflict of interest. Again, this is why they're making this presentation, this argument to the court as a justification for taking the appeal before the trial is over. This is the exception to the rule. Ordinarily, you've got to wait until somebody gets convicted and then you appeal, and you basically throw everything into the appeal that you think the judge got wrong all the way from the beginning and all the way through trial. But in some cases, it's so important that the Court of Appeals needs to get involved, and this is where we are now. They point out here that a conflicted prosecutor who proceeds with a prosecution nonetheless casts this odor of mendacity over the entire proceeding that cannot be corrected or remedied after the fact. The odor negatively impacts the public's perception and confidence in the judicial system. And this is a structural defect. By that, they mean that the case itself is unsound structurally now, and that it can only be corrected by immediately, not later, but now, rooting out all sources of the conflict. By that, they mean not just letting go of Special Prosecutor Nathan Wade, who is the paramour of the district attorney, but all sources of the conflict, and that would include the prosecutor who caused this and her office. And by the way, if she is recused, everybody in her office is likewise recused because their authority in the case flows from hers. And so if she has none, they have none. They point out that neither a slap on the wrist nor removal of some of the conflict will suffice. Some errors are so fundamental and pervasive that they require reversal without regard to the facts and circumstances of the particular case. And then they go on to say an error is fundamental if it undermines the integrity of the criminal proceeding. All right, so ask yourself, guys, I mean, do you think that the integrity of a criminal proceeding is undermined if you have a prosecutor essentially getting kickbacks, which is not even the worst of it? In my opinion, the worst of it is going into the church and calling the defendants and their lawyers racists and liars. And that's the extrajudicial, the out of court statements made by a prosecutor that are just designed to slime the defendant. And it's done in a way that's it's in the heart of where the jurors are picked from. And it's called it's called an extrajudicial statement. It's trying the case on the courthouse steps, and it's just not allowed. All right. Before I go any further, I want to check in on the chat and see what's going on. We have now 1,450 people in here. And for those of you who might just be joining us, we're discussing today the Georgia Court of Appeals has decided that they will accept the pretrial appeal. It's a discretionary move. They will accept the pretrial appeal of Donald Trump and a number of the defendants who are asking the district attorney to be disqualified for all of her alleged misconduct, to include speaking about the case outside of the courtroom, sliming defendants in the well of a church, hiring her boyfriend and paying him with dollars from no bid contracts, dollars that arguably could be better spent prosecuting armed robbery cases or paying full-time prosecutors, regular salaries, and not steering no bid contracts to your alleged, to your admitted boyfriend. Okay. All right. So before I get back into the ACLJ and their amicus brief, I want to talk more about that, but I want you to say hello to our very special guest and our friend, attorney Rachel Kaufman. Rachel, good evening. What's going on?
Surprise. Hello, everybody. Happy to be here. Hi.
So you've been in the green room there for a few minutes hearing what we've been talking about. And you and I have texted some today, but I know you were busy in court and I was busy in court and I was doing other TV shows. I was recording with Megyn Kelly earlier, so my voice is tired. I want you to talk for a minute. Tell us what you think about this ruling today.
Just like most courts, I'm always annoyed that they take so long to do what I wish that they did a few weeks ago. Okay. But that said, I'm excited to have them review the case. And I whatever ruling they come to, which I think it will result in her removal. And like you said, I think it's because it's less. I take issue with what she did with Nathan Wade, the kickbacks. But then there's like the perjury, like on the stand. There's like the saying that you paid him back in cash without receipts. It's the accusing, the attorneys for the other parties and the defendants in this specific case of being racist and misusing race against her. It's everything that's happened since she's been accused of these things that has really risen to the level of a conflict of interest, in my opinion, and should result in recusal. However, strategically at this point, I also think that keeping her on the case is great for the defendants as well.
Basically, you said that before, and I think correct me if I'm wrong, what you're saying is that because, look, if you're going to stand trial in this case, this is the person you want because she's shown an inability to be effective, essentially. And she's a distraction.
She's a huge distraction. And coming from her office, I think any arguments by anyone who's willing to actually presume these defendants innocent are going to be much more skeptical than they otherwise would be of a random prosecutor.
Yeah. Well, I guess that's the consolation prize. If they, by the way, thank you very much, Georgia Patriot. Appreciate the super chats. And yesterday, I've got that video, and if I have time, I'm going to get to it. Yesterday, there was the Georgia Board of Elections. It had a meeting, and there was some testimony about how Fulton County does or does not accurately count their votes, which does go to the heart of this indictment. So if we have time, we're going to get to that. But thank you for pointing that out, and thank you for the super chat. Let's talk about oral argument. Do you do any appeal work?
I do. I've done a little bit of appeal work. I wish I did a little bit more, because it reminds me that I have a brain and I'm not just operating in dysfunction, which is what criminal justice feels like quite often.
I don't really do appeals. I did moot court in law school. I didn't like it. I liked mock trial better, and I like, trial work better now. But, I do understand it enough to at least talk about it. So let me ask you something. Who do you think, if you had to bet, I mean, we're not going to hear from all of the lawyers, because I don't think the Court of Appeals is going to let lawyers for every defendant argue, that maybe they will. I don't know enough about it to know for sure, but I suspect that we're not going to be able to hear from, dozens of lawyers all on the same side. Who do you think might argue the interests, if you will, of the appellants? And that, by that, the appellants, folks, that's the people bringing the appeal. That would be Donald Trump, Michael Roman, and all the defendants who have joined into Michael Roman's motion. Is it going to be Ashley Merchant? Is it going to be Steve Sadow? Or is it going to be somebody else? Do you have any predictions?
Who would I pick? Well, I have so I'd pick Ashley, and my prediction is Ashley Merchant. So yeah, so I think her and John do appeals. They do appellate work. Nobody knows the facts better than they do as it relates to the claims and the motions that they brought. I loved hearing her on your show the other day, and I was on live, so I was so excited to see her, because she's a rock star, even to the people that know her. Yes, please. I will get my popcorn and watch that all day. And it'll be interesting to see from Fani's office what kind of appellate representation she gets, if she pulls somebody from outside, or if she has, and if she tries to hire a special prosecutor for that and pay for that. I don't know what she's going to do. I ran into Adam Abadi the other day in the hall. He knows I'm mad at him. So I don't, it's hard. There's certain people in that office who I just like Adrian Love. I just can't, they know. I mean, we all know. I just don't like you. I had something else to contribute, because I actually happened to run into Judge McAfee the other day on the streets of Atlanta.
Well, you're the second person this week that another guy that I know, my friend, who apparently Judge McAfee lives pretty close to me, because my friend texted me, said he saw him walking the dog the other day. But you tell your story. Well,
just that I said this before, and I'm not defending decision. I'm not discussing his particular decisions that we've talked about before. In general, he is an incredibly fair, even-minded, open-minded individual who, he didn't run for judge to become a judge. He was appointed by Governor Kemp. And so he is not really a politician by nature. I don't think that I think he's going to win his race, but I don't think that he enjoys the political fight while he's trying to be a fair-minded judge. So what I do think is going to happen is, I think that after the election, I think there'll be a number of rulings that come out. But I think that beforehand, while he's running, he'd be accused of anything that he did would be political to the people that wanted it to be the other way. So I think he's trying to avoid that. And so he's kind of, I also learned that his law clerk does not do his research for him.
Wow.
He does, his law clerk does civil stuff, and he does all of his own criminal research.
That's fascinating. I would not have guessed that. That's certainly good insight. You said that you think he's going to win the election. I don't, but look, I hope you're right. And let me say about this. The reason I'm concerned is because now we're down to 2. The election's in like a week from now. It's like the 21st. So just right around the corner here in May. It's the nonpartisan judicial race. So if you pick up a Democrat ballot, or if you pick up a Republican ballot to vote in the Republican primary, you're going to get all the judges, and they're supposedly nonpartisan, even though you know what their, their partisan, issue. What you know if they're a Republican or a Democrat.
I don't know if Scott McAfee is a Republican or a Democrat.
Well, I mean, he was appointed by Governor Kemp, who doesn't appoint Democrats to the bench, and he's in the I think Federalist Society. He's got all of the bona fides, if you will, of a conservative Republican candidate. But be that as it may, let's just take a look. I've saved this for just such an occasion. This is Robert Patillo, I guess a Facebook post or something, maybe Instagram, whatever, from before he was running against Judge McAfee. This is a guy who absolutely, there's no way this guy could ever be fair. And this is, if Robert Patillo beats Judge McAfee, this is the guy who would take over the case. And of course, he would then be subject to motions to be recused from the case for those reasons. But Fani Willis handpicked that guy. Okay. I believe she handpicked him, and she would basically use her political apparatus, which is formidable. And she would use that against Judge McAfee, because Judge McAfee, some of us disagree with some of his rulings, like this one that we're talking about tonight, but he's not a rubber stamp for her. So she has a reason to try to get rid of him. And I think that's it.
I think that she's having a hard enough time maintaining her own public image and correcting it, that her power is not extending to Darius Patillo versus Scott McAfee. I don't know about you. I have not seen one sign for Darius, or what's his name? I'm sorry. I know Darius Patillo, which is someone different.
Robert.
Yeah. Darius Patillo is the Henry County DA. So Robert Patillo, unrelated, possibly. Yeah, I haven't seen anything for him. So I don't know who he is. Even if she is behind his campaign, where is his campaign?
All right. Well, we'll see. We'll see what happens. And a lot of it has going to be the turnout, right? So there's not going to be much of a Republican primary in Georgia, but there's going to be some issues. I think the Democrat primary is going to be hot. So you're going to have more of those ballots going out. So we'll just have to see. We'll see how it plays out. When there was 3 people in the race before one of them got disqualified, the idea was that he might at least place second and make it to a runoff, because you got to get 50% plus 1. And so with 3 people in the race, there's the potential for a runoff. All right. Question for you, Rachel. Have you ever filed an amicus brief?
No, I don't think anyone cares someday maybe people will care enough about what I say that I could sign an amicus brief and somebody would read it and be like, that's what we should do. We should listen to her. But no, I mean, conceptually, though, it's a really important mechanism for people who want to involve themselves and their opinion in a court's decision. So.
I want to spend just a few more minutes just hitting some of the high points of this. They point out that there is a reason for severe treatment of prosecutorial decisions that undermine confidence in the integrity of the criminal proceedings, including those which can generate the appearance, and then they put in parentheses, or odor of impropriety, because our system of government depends on that integrity. And I agree with that, and I've said from the beginning, this is not this whole thing that we're talking, this is not about Donald Trump. I would be saying the same thing if the shoe were on the other foot, if this were somebody going after Barack Obama or Joe Biden or somebody else in this same way. But you can change all of the names of the defendants, and it doesn't matter, because what she has done, in my opinion, is wrong. It's the kind of thing that she needs to be tossed from the case for. And they go on to point out that it's a fundamental premise of our society that the state should wield its formidable criminal enforcement powers in a rigorously disinterested fashion, for liberty itself may be at stake in such matters. And I think liberty is at stake, because the prosecutor, and only the prosecutor, has the awesome power. By awesome, I mean tremendous power to bring criminal charges, to convene grand juries, and to throw people in jail. All the people that she indicted had to go turn themselves into jail. And if there wasn't a bond, they'd still be there. So that's the power that she has, and it must be wielded with integrity. And I also agree with this statement that the integrity of the not just Georgia's justice system, but the justice system in America, implicating its prosecutors and its courts, is literally at stake. I think that that's what this is all about. And I think that's why that they're going to have to go ahead and toss her from the case. What do you think?
Well, I think that's also a really good way for whoever the trial court judge is, which in this case, it's Scott McAfee, to really not be the bad guy. I mean, I understand. I want a judge to have a spine. I think if he had been on the bench longer, maybe he would have been more fed up. I don't know, but I know that what's going to happen at the Court of Appeals is that somebody other than the trial court is going to make a decision on this. And Madam DA is going to have to deal with it.
Why do you say Madam DA?
That's not nice of me. That's me being a little bit of a,
No, it's because that's what she wants to call her.
Her name's Fani Willis. I've known her. Her name's Fani Willis. When she became the DA, she wanted to be called Madam. I don't know.
Yeah, she literally goes by. That's what people in the office call her. That's why I pointed it out.
Yeah, I knew her before all of it, and so I guess power does weird things to people. That's sad.
All right. So just another little bit of this, and they point out here that the appearance of impropriety is unacceptable. Again, we're talking about eroding confidence in the judicial process. It is particularly necessary to hold prosecutors accountable for their conflicts of interest because prosecutors exercise considerable discretion in matters such as the determination of which persons should be targets of an investigation and which persons should be charged with what offenses and who should be utilized as a witness. And I highlighted this because I want to point out, some of you probably know this, but in case you don't, Fani Willis has already been disqualified by one Fulton County judge for having a conflict of interest. And it's regarding a man named Burt Jones, who's currently the lieutenant governor of Georgia. He was one of the targets of her investigation back in, early in this case when it all started, when it was going before the special purpose grand jury, but before Burt Jones was elected lieutenant governor and before Fani Willis was elected district attorney, because they both took office at the same time, having won the November general election in Georgia in 2020. She had participated, correct me if I'm wrong, Rachel, she either participated in or held a fundraiser for Burt Jones's political opponent who was running for lieutenant governor, who happened to lose. But because she had
time out, more tea for everybody. This is the irony and the hypocrisy of people who consider themselves to be liberal. Okay. And I don't know where I am. I'm a radical, so I don't fit in.
Well, she had a conflict of interest though. and she was recused by another judge because look, you can't have this kind of political bias and then include this person as a target of your investigation. If it was good enough, if that was a good enough reason, campaigning on I'm going to get Trump ought to be a good enough reason, but also all of these things I think pale by comparison. So
Charlie Bailey though, liberal candidate, Fani Willis is supporting him. Let me just say this, that I had a trial in 2017, miserable experience. Adrian Love and Charlie Bailey, who was Burt Jones' opponent in the race that Fani Willis supported. Well, wouldn't you know, folks, Mr. Liberal and Adrian Love decided to strike every black male from our jury in a gang murder jury. It was a gang murder trial and the defendants were black and they struck every black male. So I remember when Charlie was running first he was running for attorney general and then he switched to the lieutenant governor's race. But when he asked me for money, I was like, dude.
So you're saying that prosecutors will engage in illegal jury strikes, which by that I mean violates what we call the Batson rule. You can't strike people just because of their race.
To pretend, yes, and to pretend like you're like some like righteous liberal person, like Fani does, like saying that she doesn't want to emasculate a black man. It's like respectfully or disrespectfully, you do that to so many others, just the ones that you aren't having an affair with. Like same with Charlie Bailey. So you're a Democrat in theory, but when it comes to giving somebody a fair jury trial, you and Adrian you know, you don't want to give people a fair trial and you use your power the wrong way. That's
All right.
it. Sorry, just had to tell everybody what happened.
Well, look, there's so many, we could talk all days about stories about the Fulton County District Attorney's Office and the stuff that goes on there. Just to kind of wrap this part of it up, this amicus brief, they cite to the trial court's own order, and they say, as the court below, that means that's a reference to the trial court because they are below the Court of Appeals. As the trial court acknowledged, even when no actual conflict exists, a perceived conflict in the reasonable eyes of the public threatens confidence in the legal system itself. When this danger goes uncorrected, it undermines the legitimacy and the moral force of our already weakest branch of government. So the basic theme here is protecting the credibility of the court system. They go on to say, in the present case, merely stopping the continuation of repeatedly made bad choices, and that's the judge's words from his order, is not enough, nor is the removal of some of the conflict. The law deserves and requires more than that. It requires the disqualification of all conflicted parties. And so they're making a reference to Nathan Wade and Fani Willis. This court should ensure that the odor of mendacity that pervades this case is removed before it's too late. And of course, today, for those of you who are perhaps just joining us, the Court of Appeals of Georgia said they're going to at least agree to hear the appeal. They're going to be asked to do just that. They're going to be asked to toss Fani Willis from the case. If you're in the chat and you agree with what I'm saying, you disagree with what I'm saying, or you disagree with something Rachel says, let us know. I want to hear what your thoughts are about this case, what your thoughts are about this appeal. I want to see what questions that you've got because we want to talk about all of those things. By the way, there's 2,000 people in here. Hang on. You got to hit the like button. Okay. There's 2,000 people in here. Make sure you hit like because that's how YouTube knows that this is popular content and helps people find the channel. And if everybody will just go ahead and hit that for me right now, that would be great. Beth says, what is this woman's stance on crime? I guess you're talking about Rachel. Rachel,
I'm so happy you asked.
Rachel supports crime, don't you, Rachel?
That's what somebody else said, because I'm a defense attorney. I support crime. It's so untrue. What I'm against is like the mass cast net fishing of people that may share similar beliefs and values or like socioeconomic status or I don't know wherever they live, and they just group them together, and they don't want individuals to and their criminal intent to be considered. I'm for accountability, but when accountability looks like mandatory minimums of like 25 years for someone who is standing around or gave their friend a ride, even if their friend's a piece of shit, like you shouldn't be getting those kind of. So I'm not for crime. Certain things that are criminal, I don't believe are criminal. Rules are meant to be broken, but not all of them. So I just want to be very clear. As a defense attorney, I choose what cases I take.
Well, this is what this is about. This is about fundamental fairness. I can't imagine anybody, unless they're being intellectually dishonest, I can't imagine anybody who's not in support of a fair justice system. That's what we want. We want the system to be fair. We want it to be one that plays by the rules that is designed. Look, you're presumed innocent. The prosecutor has to prove your guilt beyond a reasonable doubt. That's a very high burden of proof, and they are not entitled to take away your liberty unless or until they do those things through competent, reliable evidence. But a fair trial starts with, as much as you have a right to a jury trial, you have a right to a fair-minded prosecutor, one who is objectively seeking justice, not one who is on a mission to get an individual person or persons, not one who's trying to make a political statement, not one who's trying to target a political opponent, but you're entitled to one that is fair and who is objectively seeking justice.
Yeah. So the problem with Fani's prosecution of Donald Trump and company is that she hired, in addition to everything else we've discussed, and we've mentioned this on prior podcasts, she has hired media and PR companies to maximize the impact of publications she makes on Instagram and other places about the specific case. And so and I don't know if that's her personal money. I don't know if that's my tax dollars. Please, may it not be my tax dollars.
No,
but
the media monitoring, that was tax dollars. That was part of what Ashley brought out. And I think she used tax money to pay tens of thousands of dollars, as I recall, of taxpayer money to hire this company to basically make sure her media star was rising sufficiently to basically determine, is she getting good press? Is she getting bad press?
It shouldn't be about her. That's the point. That's the point. You should be a neutral. You're not supposed to have an interest in the case when you're prosecuting a famous person. Maximizing your own fame from that, especially on tax dollars, should demonstrate a conflict of interest to me. I don't know about you.
All right. Well, Rachel, when do you think we're going to hear? When do you think we're going to hear the oral argument? I mean, I'm going to say before you answer, I say 60 days. I think it's going to be July. I think I'll probably be at the beach somewhere in Florida when we're live streaming this.
I definitely think before the end of the summer. I think 45 to 60 days. I'd like things to move quickly, but I'm always disappointed that they don't. I mean, I think the attorneys, at least for the defendants, are ready to go.
All right. So let's say we have July, how long do you think it's going to take them to make a ruling and to issue their opinion after they hear oral arguments?
Well, I mean, given the fact that we have an election coming up in November, I would imagine that, time is of the essence. I've had judges wait, a year to rule on an appellate issue. You can't force them to rule. I would like to think that they're going to move quickly, as it's a very narrow issue that is time sensitive.
Well, but so once they rule, though, let's just say they rule against Fani Willis. Fani can ask for a rehearing before she can move for reconsideration. She could ask for a rehearing with the entire Court of Appeals, not just a panel of three. We call that an en banc. I
dare her to do that. That would literally just,
and that would, that's going to, and then of course, you've got the Supreme Court. Whoever loses gets to appeal to the Supreme Court of Georgia, right? So, I mean, I just don't see any way this case, it could, no matter what happens, I think it's dead in the water for this year. Now, and this brings me to another point, and we discussed this when I was on Megyn Kelly's show earlier today. It was a recording. It's going to be dropped either later tonight or tomorrow. You'll hear us talk about this, but the question was about whether or not the trial court can conduct any business related to this case right now. Now, before today, the case was not officially on appeal. So now that it's officially on appeal, I am of the opinion that the trial court, Judge McAfee, loses his jurisdiction to do anything, because up until now, he's been having motions and hearings and doing other business related to the case. And that activity has been taking place. In fact, in his order granting the certificate of immediate review, he said that, the work of the court was going to continue while they, pursued this with the Court of Appeals. But I think now that's got to stop. But I know that other lawyers don't agree with me. Some lawyers involved in this case don't agree with me. And I want to know if you have a thought about that.
I've never had a case that was on appeal that the trial court retained jurisdiction. I guess I'm not an expert in that area. It seems kind of counterintuitive. However, I can tell you, as Judge McAfee said in the order, it seems as though Judge McAfee's intention is to, as soon as he can, in a non-political way, begin moving the motions to, make rulings. And I think because there's not going to be a runoff situation, because he's not running against two people and only one, the case is going to happen to move faster, if I had to estimate. All right. He wants to keep going. Because I think
I think if he had it to do over with again, I think he would have not taken the case, because he didn't have to. He could have recused himself the minute he got randomly assigned this case. He could have picked any reason and said, okay, I don't want this. This is a political hot potato, and put it in the lap of somebody else. And And I would be willing to bet money right now he probably wishes he had done that. But this is a question. Okay, this is not directly about this case, but it is about
Let's go to YSL.
certificates of review. It's about Young Thug, another racketeering RICO case, massive one brought by Fani Willis. The courts are choking on it. Teresa asks, have one of us explain how Glanville, that's the judge in the Young Thug YSL racketeering, Young Thug being the rapper from Atlanta here, had the right not to sign the certificate for appeal that Steele requested. Now, I did not know that Brian Steele had requested a certificate of review, but the answer to the question, I believe, is that it's always discretionary. Judges do not have to grant discretionary certificates of immediate review. What do you know about this one, Rachel? You follow that case more closely than I do.
That's absolutely correct. Judge Glanville wants this case to go the distance and make it to jury deliberation and hopefully to verdict. You and I have both predicted the unlikelihood of that, given just how long it's taking and how many aspects of it could create mistrials. I think Judge Glanville, because we have a jury seated, they're this far in, he's not going to stop the case to allow a discretionary appeal. Whereas because of where the case is at with in Judge McAfee with, the Trump and company defendants, I think that it doesn't hurt to punt it to the Court of Appeals. And I think that because there's less precedent in that area, I think it makes sense to possibly do that to create new law. Whereas the issues in the Young Thug case are different. So I understand why Glanville is not granting interlocutory appeals at this point.
Well, to be fair about it, most of the time judges don't. I don't know why. I personally think judges should grant more of them, but they don't, because they don't like to even admit there's a chance that they were wrong. A lot of times it's just because they're stubborn.
Yeah, nobody likes to be corrected publicly, especially agree to allow somebody else to review your legal analysis of something. Feels like, I don't know, sometimes you don't want to do it strategically because you're not trying to piss off the judge. I'm not trying to make the judge be belittled or me think that he's that out of line. In Glanville situation, it's different, but I'm fine. I
want to address this question, but before I do that, I want to make a request of those who are in the chat. And I've seen, my friend Eric Hunley, who hosts a number of shows, including, he's been a guest here as well, but America's Untold Stories. He, on his YouTube channel, he likes to ask people, look, because in the chat room, people are talking to each other and laughing and sometimes cutting up, which is great. I love to see it. By the way, I always go back when I look at these. Sometimes I watch the replay and I go back and try to look and see what the chat conversation was that I may have missed while it was live. But if you have a question, start by write the word question, and then go in to ask me what your question is, because I might miss it. But if you label it as a question, we're more likely to see it. But Mary is asking, who are the judges that will hear the appeal? The answer is we don't know right now. And it's my understanding, see, that they use these panels of 3 judges. They're called divisions, and they involve 3 judges in each division. Apparently it was one division that heard today that ruled today that they're going to hear the appeal, but it's my understanding it's going to be a different division that will hear the merits of the case, which is, should she in fact be tossed from the case and the case dismissed. So we don't know who those judges will be. Somebody might know. And if you do know, I'd love you to tell me. And we'll know soon enough which division it's going to be assigned to. I just haven't had time today to try to figure it out. And I don't know if the case has even been assigned, because I don't know how the inner workings of the Court of Appeals make that determination.
We'll ask Ashley. She's the one that taught us that. That's how I learned.
I've already asked her, but I haven't had time to check to see if she's answered.
Yeah, she's the end. Yeah. She'll know.
All right. So anyway, it's going to be 3 judges that remain to be seen, but we'll be able to tell kind of what their thoughts are from the questions that they ask. Here's another question, a little bit off topic, but close enough. Kate's asking if she's subpoenaed and refuses to appear before the Senate committee, what can they do and what do you think they will do? So I do think she's going to be subpoenaed, and I think she's setting up a fight. She's going to move to quash the subpoena. She's going to say that it's illegal. And there's going to be a court fight over it, and it's probably going to be decided by a Fulton County Superior Court judge. That's my prediction. Rachel, do you have one?
I mean, I guess she can be held in contempt.
Contempt of the Senate? I don't know. This is all new territory. I know that when they had the hearing the other day, we live streamed it here 4 hours, by the way. It was over. They had Rob Pitts and the chief financial officer of Fulton County talking about budgeting and how they give Fani all this money, and then they really can't control what she does with it. But anyway,
she loves to tell you that too.
Former Governor Barnes, who was a witness in the hearing to disqualify her, was in the room, and I'm told that he was there for purposes of representing the interests of Fani Willis as an attorney. Had you heard that?
No.
Had you heard that Roy Barnes was there on her behalf?
No.
So I think what's going to happen is they're going to subpoena her, and she's setting up a legal fight against the jurisdiction of the Senate committee. So that's where I think that one's headed.
This reminds me of, it's like transparency in kitchens at restaurants. You know, if you have nothing to hide, like what is in your kitchen? Like what is the deal? Like you're a public official. Like we should be able to come inspect what you're doing. And she got in the stand before. She ended up not fighting that subpoena. So what's the difference now? She wants to talk.
If you don't show up for her subpoena before her grand jury, even one that, arguably has no jurisdiction, she's going to have you arrested.
Yeah. Oh God. Yeah. You might die in the jail waiting for bond. Like who knows?
Well, fortunately, we haven't had any, at least I'm not aware of any new jail deaths. For those of you who wonder what we're talking about, we've done some other live streams. They're on the channel. Go check them out. I usually call them Fulton County Follies or something of that nature, where we've talked about the systemic problems that plague Fulton County generally and the justice system in particular. We have a severe backlog of cases. We have people dying at the jail at rates that are just alarming. And you have resources of both, law enforcement and prosecutorial resources being spent on all kinds of things like Sprinter vans that nobody can find. It's really more than we can get back into, but go back and watch some of those previous videos that Rachel and I have talked about. It's really remarkable. Megan says that Rachel's going to be hired if she pops up in Fulton. So you've got a new client, looks like.
Oh, it'd be my honor. It'd be my honor and pleasure. I will. Yeah, I love stomping through. The courtrooms and the courthouse. It's fun. It's fun. I actually saw a number of the attorneys because I told you I'm on the Cop City case, which has 61 co-defendants. So I was on another RICO case this week. My father was actually in town visiting from California, and I brought him into the courtroom. You would hate this, Phil. The judge required all the attorneys, 61 plus attorneys, to wear masks in the courtroom.
When was this?
This wasn't last week. This was like 2 days ago. I can't keep track of life, but yeah. So we were all packed into a courtroom, and actually Max Shard and Bruce Harvey came upstairs while they were waiting probably on some sort of break from YSL downstairs. So there was like 65 attorneys in the room for this other insane RICO case that if you're having issues with the jail, if you have a backlog, I understand that people need to be held accountable again, but like trim the fat off this stuff. Like, what are we doing? 61 defendants? What is happening?
Georgia Patriot asks if we have any insight on the candidates running for the Open Court of Appeals. I'm going to be honest with you. I have not been following that as closely as I ordinarily would. My brain is full with a lot of things I'm doing, trying to grow this channel. My brain is full following the twists and turns of all this lawfare, particularly this particular case. I can look into it, but Rachel, have you been following it? I hate to not be able to answer your question, particularly in light of the nice super chat. Thank you for that, by the way, but I'm afraid that I haven't been following it.
No, but I think that what we should do at some point, because I think it'd be good for both of us to research, but then also tell everybody a little bit more about, we could do a little bit of like local elections, like who, there is somebody running against Fani Willis, at least one person, Christian Wise. I don't know, Smith, I don't know what he's going by these days.
Well, yeah, well, it's Christian Wise Smith, but of course that's in the Democrat primary. And we've got the Republican Courtney Kramer, that'll be in November at the general election.
Okay. Well, we could just update everybody. And I hate listening to political ads, and I hate signs in my yard. I haven't
seen any Fani Willis signs anywhere around in Fulton County. Have you seen any?
I have. I've seen a few. I kind of chuckle when I saw a Pat Labat one the other day. I'm like, I mean, it's a job that nobody wants. I mean, I feel like it's the same with the presidency. It's like the people most qualified that would be best for it don't want to do it. If you didn't have to campaign, and I actually talked about this with Scott McAfee because he's having to campaign this time around. He told me he's been going to churches on the weekend, and he's been actually very well received in a lot of the predominantly African-American churches in South Atlanta, that they're happy to see him. And I don't know. I think,
well, I bet he's probably not going to Big Bethel because
maybe not Big Bethel, but he's going to a number of other places. And so
Fanny has the lock at Big Bethel.
I don't go places on Sundays, and I don't like crowds in general. So I couldn't do it. So that's why.
Thank you. Thanks to all by the way, there's 2,000 or so folks still in the live chat. Thank you. Or in the live stream, a lot of folks in the chat. It's really hopping. Thank you all for participating, and everybody who's here, go ahead and hit that like button for me, because that's what helps people find this channel on YouTube. And by the way, I'm closing in on 30,000 subscribers. I'm not there yet. I just crossed over 27, but my next goal is 30,000 subscriptions. So if you haven't subscribed, please do so. And if you have subscribed, grab your spouse, grab your kids, grab your mail carrier, your next door neighbor, set up an account for your dog or something, and tell everybody to go ahead and also subscribe.
We should start a dog channel and become dog show.
Yeah. Yeah. And thanks for this, like the super chats. That kind of support is very helpful. It helps me continue to provide and bring additional content. There's some links in the show description with additional ways to support. So check those out if you don't mind. And thank you all very much for helping us do that. Rachel, what do you predict is going to be the outcome of this appeal? I'm going to just go ahead and put you on the spot. We're going to record your vote right now. What is your prediction? And specifically, is it going to be a unanimous 3-judge panel, or is it going to be a 2-to-1 vote? What do you think?
I don't believe in gambling, but Back to the Future 2 is my favorite movie. So I wish I had the almanac and I could actually make money on this, but that'd be the wrong way to go. Anyways, I'm thinking, even though I do think there's a conflict of interest, they think they're going to kick it back. I think they may let her keep it. So I think that they're going to deny the disqualification at 2-to-1. 2-to-1. I think it'll be, I think per usual, this is just because I am never optimistic as it relates to any judicial body letting prosecutors know what's actually up. They'll give them a little hard talking to, the odor of mendacity. Have it like, you're a liar. Like, just call it like it is. What you'll notice, Glanville always apologizes to the state when he has to sustain their objections. It's like, why is this? It's just crazy.
I think, look, I'm going to predict that they're going to toss her, and here's why.
There's nothing more powerful than the odor of mendacity.
And I think that the Court of Appeals knows that this case literally reeks. I think that they watched the news, saw what happened. They're going to be very aware of what happened in the trial court. They're going to be aware of the testimony where she ran in there like a wildcat with her tail hair on fire, just running in there in the middle of a hearing to quash her subpoena. By the way, she barges in, takes the stand, starts calling people liars. So, that none of that is lost on these people. And they are human beings who are aware of current events just like we are. So I think they're going to toss her. They're probably going to look at the interview done with Nathan Wade this week, ABC. They're going to look at Fani Willis going back to the steps of Big Bethel and participating in this campaign news conference where she gets the clergy to refer to these defendants as evil. And she, says that Trump, for example, has no redeeming qualities. Look, you can't go out in public if you're the DA and talk bad about people that you're currently prosecuting. You just can't do it. And the courts just can't let prosecutors get away with it. So I think she's going to lose the appeal, and I think it's going to be 2-1. Now I'm going to go on record right here. I even jotted it down. I think it's going to be 2-1. Willis loses, but you think Willis stays on the case by about the same vote, 2-1. Is that right?
Yeah, we'll go 2-1. I think somebody and their law clerk are going to have fun writing a dissent one way or the other. What up, Edwin? You're not teasing. It's okay.
So Senior Chief is here, retired from the submarine service, Rachel. I don't know if I could, I just don't know that I have it in me I'm probably claustrophobic, but to spend your entire career in the Navy to retire as a senior enlisted person from the submarine service is incredible.
My crazy ass for my birthday this weekend, I'm turning 38. I'm going to, I don't know why I'm telling you this. I'm going to a sensory deprivation chamber where you lay in water.
I've done it. I've done it. I've done it. I did it. Somebody gave it to me as a birthday present a few years ago. It was over in Decatur, I think. And you lay there in the pool and you put ear like plugs in, and it's highly salinated salt water. So you're floating on top and your ears are just kind of just beneath the water. And so you kind of begin to, it's not like you go to sleep, but you lose, you can't tell what's up and down, left, right, or sideways. It's an interesting experience.
Very excited. So yeah, I can't imagine doing that for a career, but I'm going to do it for 60 minutes. I'll let you know.
Well, speaking of 60 minutes, we've been here over an hour. Rachel, thanks for stopping by. We're going to go ahead and have to wrap it up, but you're going to come back soon. We're going to do another show. We're going to get more into Young Thug and all that stuff.
And we have to have a dog channel. I'll let Marcus. Hold on. This is Marcus. He wants to say hi, Marcus.
Oh, hey, Marcus.
On screen. This is Marcus. I have another dog somewhere else, but he wanted to make it.
All right. Well, I'm glad. Nice to meet Marcus. And thank you. We'll catch you next time. And for those of you who are here, thank you again very much. I really enjoy the banter in the chat, and I appreciate the help. It's one of my things that I like to do when I get the chance to go back and look at these videos after the fact. I look at the chat because I like to see what people are interested in, because I try to incorporate these ideas. So if you got something you want to tell me, leave a comment here, or if you're watching later, you're not in the live chat, put a comment on this video, because I do go in and look at them as much as I can, because I try to incorporate ideas and look for ways to improve. Please hit that like button. Tell all your friends to subscribe. And by the way, if you have forgotten about who exactly Fani Willis is, this is who she and her team of prosecutors rely on as star witnesses in a major racketeering case.
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break soon. Hang in there.
Thanks again, everybody. We'll catch you back here next time inside.